I will start by saying I really do like this setup. I feel like I should be announcing that I've just signed for a football team rather than talking to you. Hopefully, everyone here is aware that we're about to start talking about crime and a life of crime and why it may or may not be the correct paths for all of you to go down. I thought it'd be worth starting off by telling you a little bit about my own route to get to where I am at the moment. Before I do, it's very well worth making it clear that there is no ideal route in order to get to the bar, and that's any part of the bar, whether it's crime, civil, chancery or commercial. There isn't a golden answer. So I'd like to apologise in advance. If you're looking for that, I'm not going to be able to give it to you today. Now, I decided to do the 3-year undergraduate law degree at the University of York in what was only their 3rd year of running a law programme. So it's fair to say at the time they were still finding their feet, just as I was finding my feet, having not done any form of law prior to that point. I decided to stay up north and do the BPTC in Leeds. There's far too many individual letters that we like to use for that sort of thing. And managed to get a very competent grade on the bar course, having only got a 2-1 grade during my undergraduate degree course. If you get a 2-1 grade at university and are very competent on the bar course, you are decidedly average. That is, unfortunately, the simple facts of the matter. Most chambers will be looking at a 2-1 and a very competent at a minimum, unless there are mitigating circumstances that would take you outside of that bracket. Now, I got called to the bar in 2014 after I completed the bar course that year and got called to the Middle Temple. Now, we're here now in just on the end of 2019. I started my pupillage and I did a mixed common law pupillage on the 1st of October 2018, and so I've only just finished my pupillage as of the 1st of October of this year and got taken on as a tenant. And I think that's ultimately one of the reasons as to why I was invited to come along and do the talk to you today, because I know a bit about where you are at the moment and what the current situation is like in terms of applying for pupillages and trying to take your careers to the end goal, which hopefully for all of you will be to get tenancy at a chambers somewhere. A lot of people may well find themselves in the same situation that I was, of having finished the bar course in 2014 and being a qualified barrister at that point, then trying to go through the chaos of the pupillage application system. I've had an awful lot of people already today coming up to me and asking, is there anything that I can put into my pupillage applications to stand out from the rest of the crowd? My simple answer to that is anything that you have done in your lives can be something which is useful in your applications and pupillage interviews. I was talking to someone earlier and I mentioned to them, for example, when I was 18, I worked at a theme park as my Saturday job, working on the front ticket desks, dealing with all sorts of weird and wonderful queries from people. For example, I got asked by an adult why it is we do not have a net over the top of the penguin enclosure to stop them all escaping. It was at that point I had to highlight to him, unfortunately, penguins can't fly. And so that wasn't too much of an issue for us. But I actually brought that up, strangely, in one of my pupillage interviews as an example of a situation in which I got asked a question which to me seemed very straightforward, but to somebody who didn't know the answer, wasn't from a background of knowing that penguins can't fly, just as many people aren't from backgrounds in which they understand the finer points of the law, but explaining it to them in a nice way so that they are not belittled in any way, but go away with a greater understanding than they did beforehand. Now, of course, me working in a theme park has absolutely nothing whatsoever to do with my current position now as a common law tenant, but it just goes to show that absolutely anything can be used to move forwards your application. So when I found myself in that difficult position of not knowing what to do, I decided to set out and get some practical real-life work experience. So I spent 6 months with a criminal solicitor's firm who dealt with the defence of particular serious sexual assault allegations, and that was effectively their main area of practice. And in particular, I dealt with their appeals cases as a paralegal, supporting their team of solicitors. Whilst doing that, I also decided what I really needed to set myself apart from other people was to get some form of practical, real-life advocacy experience, because after all, I wanted to be a barrister rather than a solicitor. So I decided to sign up with one of the many county court advocacy agencies that there are now that operate in the United Kingdom, which meant I was effectively doing the work of a very junior barrister for a lot less pay than a junior barrister receives. But it meant then that I was able to talk about real life things that only a barrister would be able to know about. Things like knowing that there may be days in which you find yourself on a floating list and your case doesn't get called that day, and you spent the entire day with your clients trying to be productive, trying to move the case forwards in some way, but you simply can't because something has gone wrong with the court system. The next area I wanted to cover was about why it was I decided to come to the bar. Quite simply, that's because I love the sound of my own voice, as you may well have already noticed. I seem to have a very good trick that I learned at a young age when I was in a primary school production of Oliver, and I was Mr. Bumble. Apparently I terrified most of the school in yelling "what?" Very loudly in response to Oliver's request to please have some more. And it was at that point I realised that I had a particular skill of projecting my voice large distances and being fairly engaging to people. And when you're engaging to people, you can convince people about your way of thinking, which is an ideal skill for a barrister when you are trying to turn a jury's opinion round to your client and your view of the particular case. I also wanted to join the bar because of the fact it's a profession. Most barristers will be self-employed. Even if you're employed with something like the CPS, there is no profession which is quite like being a barrister. It's got completely different stresses and strains to a lot of other professions, but there are also a lot of other benefits that you just simply do not get from any other form of profession or work. Specifically, why crime? It's because, to me, crime is the most interesting. Most people's first views of the legal justice system will be based on what they have seen on films or on television. In particular, the amount of times in which I get asked by clients before we go into a courtroom, is this going to be like Judge Judy? And I have to explain to them that there's many, many reasons as to why that's not going to be the case, and why it's also not going to be like Judge Rinder, and why Suits is not a sort of legal basis upon which the British justice system is built. It's only natural as well that when people first hear about the law, they think of crime. They think of barristers as being the people in the wigs and gowns. You speak to a lot of people that aren't in the law and ask them if they know what the difference between a barrister and a solicitor is. And the first thing they will say is, well, barristers are the ones that wear the wigs and gowns. Of course, we don't always wear wigs and gowns. In the magistrates' courts, generally, we won't be wearing wigs and gowns in particular. And indeed, in matters involving youths, now it's becoming more commonplace for wigs and gowns to be cast aside. But what interests me in particular about crime is the individual facts with crime. It's how serious crime is. A lot of people join the law because they're interested in human rights, and they want to uphold fundamental basic human rights. Well, if you want to get into human rights, crime is the best place to start. You are dealing with the right to fair trial. You are dealing with the right to a private life because you are dealing with people's liberties and justice and that sort of thing on a regular basis. To me, there is no other area of law which is quite like crime, and I say that as a mixed practitioner myself, because I have both a civil and a crime practice. In terms of the types of cases you'll be looking at, please don't expect to straight away be going to the Old Bailey or straight away be dealing with any form of murder cases or anything like that. If you don't already know, during the course of your pupillage, it's split into two halves, and your first half of the pupillage will be following around a pupil supervisor. If you elect to apply for crime pupillages, the likelihood is you will be following a crime practitioner and spending the majority of your time learning directly from them. Most of the time they will be senior practitioners, so you will be in the Crown Courts, and you will be seeing cases which aren't necessarily a good reflection of what you will be dealing with as soon as you get onto your feet as a Second Six pupil. So when you move into Second Six and you start doing your own cases, in all reality you are going to be in the Magistrates' Court to start off. It's where everybody starts off to cut their teeth. Please never see being in the Magistrates' Court as in any way being below you, because as soon as you start talking to clients in the Magistrates' Courts, you find that they take their matters just as seriously as people in the Crown Courts. For example, you may come across cases where you are arguing about whether someone should be keeping their driving licence or not. You may well think, well, people don't need to drive in this day and age, but if they rely on the ability to drive for their work, well, the possibility is they're going to be losing their income as a direct result of losing their driving licence. There are going to be people who are going to be indirectly affected as a result of your client losing their driving licence because of the fact they rely on them for their domestic duties and rely on them for their income as well. In terms of the types of cases you'll be doing in the Magistrates' Courts, you'll be doing a lot of first appearances. Saturday court is a word that you will hear being thrown around between pupils and junior tenants as well. Yes, your chambers may well require you to work on a Saturday morning as well, dealing with anybody who's been arrested overnight on the Friday and needs to be dealt with first thing on the Saturday morning as well. Now, that is sometimes the best way to get your first grasp of cases that will eventually work their way up to the Crown Court, and you are just there to deal with the first appearance and send it on up to the Crown Court, but you may well be dealing with bail applications before sending it up. If it's a matter that can then be dealt with in the Magistrates' Court, you'll be doing some form of trial preparation or case management. We have what are called PET forms, which stands for Preparation of Effective Trial Forms, that will need to be completed. Or that will be the opportunity, depending on your legal advice, for your client to decide that is the point in which they want to plead guilty. The type of cases you will start off dealing with will, of course, be those that are summary only and will be dealt with in the Magistrates' Courts. You can get defence work and prosecution work as a junior. I myself, for example, do an awful lot of CPS lists on the East of England circuit in places like Southend and Cambridge. You may well be encouraged as well by your particular chambers to apply to the CPS to become part of their advocacy panels. And this is something that people often don't appreciate, is you can be a crime practitioner and be both defence and prosecution as well. Even if you have your heart and soul on defending people, it's very worth seeing the other side of the fence as well to understand the pressures and the strain that the CPS are under as well, and also the court system as a whole. But that's something that we will move on to in a moment. A life of crime is one which is very difficult at times from our perspective. You can often find yourself at 5:30 in the morning stood on a train station platform to which you are the only person standing there whilst it's freezing cold. You can barely see anything because it's still ridiculously foggy, and you are waiting for that one train, which is the only train you can catch in order to get to court somewhere within the United Kingdom ready for a 10 o'clock start. And in some cases, you know that even if you get that very first train, you are going to have to be late. And so you are already thinking about how you are going to be warning the court. It's a profession where you will get matters thrown at you at the last minute. A few weeks ago, for example, I was at Thames Magistrates' Court, thought it was just supposed to be a probation breach that was being dealt with. However, it turned out that in actual fact, there were about 5 different matters had been rolled up together by the court, all to be dealt with at the same time, on the same day, all represented by the same solicitor's firm, and you just have to run with it because there isn't any other option for your client to get the advice that they so desperately need at that time. Something that I'm going to discuss in greater detail later on is money. Which, of course, if you're sat in this room and you're hoping to become a millionaire as a result of doing criminal work, if you don't already know, you are going to be severely disappointed. The situation is still bad, as it is at the moment. Money is still being squeezed out of the court system, out of crime and legal aid generally, as much as possible. But very good work is being done by criminal groups such as the Criminal Bar Association in particular to try and improve the situation. And in some areas things are getting better, but I'll come on to that in a moment. Other effects on your lifestyle is because of the fact you could be someone who could be called to police stations to give advice at a police station if you work for a chambers that does that type of work. Have to do Saturday court at last minute notice, have to effectively be ready to travel anywhere within the United Kingdom suddenly if a brand new case comes in at 5 o'clock in the evening, which you then have to read all the case papers for, get hold of and then get to the court the very next day. It can put tremendous strain on your lifestyle in general, and in particular your family, your friends, and if you're in a relationship, your partner. I was very fortunate in that I got into a new relationship just before I started Pupillage. And so what I actually convinced my girlfriend to do was read a book called Law and Disorder by Tim Kevin. I heard a couple of people laugh and smile there. It's a book effectively which is a fictionalised account of somebody going through pupillage. It's quite a fun book. It really does take liberties at points, but it's very good as an introduction to people if they don't know anything about what being a pupil is going to be like and what practicing in crime is going to be like. So I strongly encourage you to, as Christmas is coming up, suggest that as a gift to friends and family if you are going to be going into a life of crime, because they need to be forewarned about what effect indirectly your choices of your profession are going to have on them. And it's much better to be upfront with the practical realities. That said, I was speaking to two senior members from my chambers, Catherine and Linda, who some of you may have had the opportunity to speak to earlier on today upstairs. Catherine does an awful lot of work on behalf of the CPS in very serious sexual offence allegations. And Linda is one of our senior crime practitioners who also has a mixed practice in immigration and family law. I asked them if they had anything that they thought would be wise to pass on to you at this stage. And one thing that Catherine in particular said to me was she was incredibly disappointed with how many people had come up to our stand today very down about crime and very down about the current situation regarding legal aid and whether it's even possible, I got asked today, to actually still survive working only in crime. Can I all assure you, the answer is yes, you definitely can still survive. We have practitioners in our chambers at the junior end who do crime only and nothing else, and they are comfortable. It depends on the particular chambers that you may be applying to as to whether they only do legal aid work or they also do private criminal work. At my chambers, for example, we do an awful lot of driving casework as well, which is privately funded, and that's a very good way of bolstering and supporting your legal aid work that you're doing as well, so that you can afford to sort of survive and continue. But being a crime practitioner is not all about the money. I can honestly say the camaraderie within the criminal bar in particular is one of the strongest of any of the legal areas that I've had the privilege to witness. The job satisfaction level that you get at the end of a full day in which you have been fighting tooth and nail from about 9 o'clock in the morning until sometimes you can be leaving court at about 6:30, and you have done the best job possible for your client and seeing the relief and the satisfaction on your client's face, there is simply no joy like it that I can describe to you. There are other times you will come out of court and you will be cursing the magistrates that you had, thinking why or how could they have reached the decision that they did. And indeed, sometimes some judges you may even have that opinion of. It's a job which is a real roller coaster. And one thing that I love is the fact that it is full of ups and downs. It's the variety of a life at the criminal bar, which I really love. Additionally, it's one of the friendliest sets of people that you're going to meet. In particular, there is a habit of, after a particularly long matter for counsel of opposing sides, to go to the pub together afterwards. We know full well that we are doing the best that we can for our particular sides, and we are all willing to help each other out as best as we possibly can. In fact, I was at a Crown Court a couple of weeks ago, and a very senior QC suddenly realised he was missing one of his collar studs that's needed in order to attach the collar to the tunic shirts that male barristers wear, and he was frantically asking around if anyone had one that they could borrow, and I think he had about 5 of them eventually thrown in his general direction. In terms of the skills and qualities that you will need in order to be successful at the criminal bar, you need to, first of all, not panic under pressure. It's going to happen. Things will go wrong. You will have matters thrown at you at the last second. You will have legal arguments raised that you may not have come across before, and you very quickly have to find out what your response is going to be. I was once told that criminal barristers should be like swans on a canal, in that they look incredibly graceful and peaceful as they're going gently across the canal surface, whilst underneath the water their legs are flapping furiously, and you don't actually see the chaos which is going on behind the scenes. So another skill for criminal barristers is to develop a poker face very quickly. In particular, there will be times during a court hearing in which something will happen and you need to assure the jury, you need to assure your client that what has happened, which is a big bombshell in this case, isn't actually a bombshell at all, and you're perfectly calm and everything's fine, whilst your brain is frantically working out what you're going to do about it. You need to have the ability to speak publicly. There's an awful lot of very old courtrooms in the United Kingdom now, which have wood panelling, which soaks up all of the sound. And you can't have a situation where the jury are falling asleep whilst you're talking to them because they can't hear you, or you're talking in a particular manner which isn't engaging. So you do need to develop advocacy skills very quickly. Those of you that are still at an early stage in your path, still at university, etc., advocacy is one thing in particular that will be taught to you on the bar course. And if your university has any form of mooting or debating, I strongly suggest that you get involved in that as fast as possible. For those of you that have already completed the bar course or are in the process of doing so, think about getting some form of practical advocacy skills outside of the classroom, as it were. The free representation unit are particularly good. You can do work for many pro bono agencies. There are things like employment tribunal friends, where you can go along and assist people at employment tribunals who are representing themselves to give them support. Or, like myself, you could go down the route of county court advocacy. Thinking of some of the other skills that you'll need, time management is, of course, a given. You will find suddenly that your best commodity whilst you're in practice is spare time and what you do with it. A lot of people ask, for example, do barristers drive to court? Well, generally you find out most barristers won't actually drive to court. They'll get public transport because they can work whilst they're doing public transport. They can't, of course, work whilst they're driving to different places. You will also have external pressures outside of the time in which you're in court. You'll have chambers events that you'll be going to. There'll be other continual professional development meetings and sessions that you'll want to go to. Sometimes you'll even give up your Saturdays to talk to people about criminal law and that sort of thing. So your ability to manage your time is going to be crucial when you get into practice. My personal view as well is one of the best qualities that you can have is to be nice and cordial at all times. That means that there will be times you're under particular stress, that you are under pressure from your client, from the courts themselves, and you will then suddenly be asked to do a task by, say, the legal advisor at a magistrate's court, or someone from witness services. One of the witnesses in your case has a question that they need answered, but you're just about to get started. One of the reasons why the bar, and the criminal bar in particular, is such a friendly profession to work in is because we all know that we're in the same boat. And if you are nice to each other and you save any form of tenacity and that pit bull nature for when it's needed inside of the courtroom rather than when you're outside, and you know how to get along with people, that's certainly a very good and important skill that you need to have. The last thing that I thought it would be worth talking about is about applications, because a lot of you will be at the stage now where you'll be applying for either mini pupillages or pupillages themselves. If you're applying for mini pupillages, my advice is, even if you are sure that crime is the area for you and that's what you want to go into, do at least one mini pupillage in another area. The reason being, it will either show you that there are other practice areas out there that you might be interested in, or it could affirm to you that you hated the other areas that you saw so much that crime is the one that you definitely want to do. And that's something that will really support you when it comes to your applications. I'm often asked, what is it that you can do in order to set your application apart from everybody else? Well, those of you that are either on the bar course or have already finished the bar course, I would be amazed if I was the first person to tell you that it's so much easier for someone who is marking your pupillage applications to discount you rather than put you forwards to the next stage. Anything like spelling errors, grammar errors, punctuation errors, using the wrong chamber's name. Goldsmith chambers, for example, Goldsmith is singular. If you put an S at the end of Goldsmith, we take that as a sign that you haven't been paying attention to the advert that was put up on the pupillage gateway, for example. And also, if you're applying for a crime-only pupillage, it's not worth telling us how much you love family law or immigration or anything like that. You need to be tailoring your individual applications to the particular set that you are applying to. One of the best pieces of advice that I can give you is, as I mentioned earlier, use your experiences that you have, show that you know what the real day-to-day life of a barrister actually is and how you would be able to cope with those circumstances. And of course, it seems silly, but having a very good knowledge of criminal law is certainly a requisite for being successful in an application for pupillage. Now, that's everything that I thought of to run through with you prior to giving this talk. I'm sure many of you have questions. So let's open it up to a general discussion. Anybody got anything whatsoever they would like answered? Yes?
If one's experience is in finance or capital markets or the city,
Mm-hmm.
But you want to do crime, would you say there's a way you can spin that experience to be relevant?
Indeed. Any form of experience can be relevant experience depending on how you approach it. And of course, one thing that pupillage providers are going to be considering is about how well you can sell yourself, how much you can convince people of a certain thing. And so you may have situations where you need to convince somebody that even though your background is in one area, you are really interested in another area. And why it is there are skills that you've got from your background or from another area which are going to make you the best possible person in crime. For example, I was asked earlier on as well, if, for example, I'm not from the UK, what do I do about selling myself for the fact that I want to practice inside of England? Well, my advice is do not hide from a challenge like that. You are going to have to meet it head on because it will come up eventually. Likewise, if you live in London and have done all your life, but you're applying to sets up on the Northern Circuit, they are going to want to know why it is that once you've finished pupillage, you're not going to head straight back down to London again and practice down there. Why is it you're interested in the north, in the Northern Circuit, and in those particular areas? So certainly, if you see any weaknesses in yourself, in your applications, or any gaps in your experience, get ready to meet those head on. Yep.
Do you think that we should try to get some formal work experience before doing the bar? So I guess my question is, are people that went straight from law school to the bar more disadvantaged to the people that have some more formal work experience before applying for pupillage?
That's a very good question to raise. As I mentioned earlier, a 2-1 and a very competent are effectively average. Now, most people, when they come to apply for pupillages, will have mini pupillages as well. My view on mini pupillages is that once you've done about 4 or 5, their worth then starts dropping from that point onwards, and sometimes it can act as a hindrance if you say that you really want to do crime, and yet you're showing that you've done loads of mini pupillages in many other practice areas. It can start working against you. So everyone will have 2-1, very competent, mini pupillages. Most people will have some form of marshalling, and indeed, when you join the Inns of Court, all of the Inns of Courts have very good marshalling systems as well that I urge you to use to your advantage. Most people will then have some form of practical experience, be it a paralegal within a solicitor's firm, which is the most common type of work that people will have undertaken. Other people may well have worked in the court system somewhere as a clerk or something like that. So with that in mind, you then have to consider, well, there's 400 people applying, I think it is, for each individual pupillage position that there is within the United Kingdom. Certainly with my chambers, what we do is we take all of the applications, sift them down to get 40 people who then go through to the first round. We then narrow that down further after the first round to the second round, down to 12 people only. Well, if all of those people have 2-1s, very competent, 5 mini pupillages, marshalling experience, and some form of practical work experience, how do you set yourself out from everybody else? Because there will be more than 40 people out of the 400 who will have all of those things. So any form of experience that you can gain, which is in some way different to what other people can gain. Think outside of paralegaling. Any form of pro bono work that you can take on as well will be of particular benefit to you. As I mentioned earlier, any form of practical advocacy experience you can get will be particularly important as well. One of the easiest ways to set yourself apart from everyone else is the practical work experience that you can get, because of course everyone would have gone through the academic side of things. Any other questions? Yeah, yep.
Another question about the question you just purely as a lay person. Can I ask potentially, if you're able, potentially talk a bit about a case you're recently working on? If you're able to speak to that.
Yes, right. Let's look at this week, for example. So I'm a common law practitioner, as I mentioned earlier. So Monday to Wednesday, I was working on civil cases. Then on Thursday and Friday, I had CPS lists on the East of England circuit. On Thursday, I was in Southend Magistrates Court for the day on behalf of the CPS, dealing with all of their trials that were listed for that court on that day. The papers got sent through to me at about 2:00 in the afternoon the day before, I think it was, and I had 6 trials to prepare for the next day on behalf of the prosecution. The trials involved driving matters, common assault, criminal damage, public order offences. It was a real mixed day, I would say, on Thursday. Friday, I then also had a CPS list, this time in Cambridge, where, again, it was a mixture of driving cases, in particular, Section 172 offences, which is where the police ask somebody to name who was the driver at the time of an incident, and people who fail to respond to those notices or fail to do so in the correct way. It's a very good question to have asked, because this is perhaps a good description as to what an average day is like. Yesterday, we had a case where someone was charged with common assault and a public order offence against 2 separate individuals. On the common assault charge, you had somebody who was alleging that the defendant had walked up to him and punched him in the head. The defendant was saying, no, it was self-defence. I myself was actually walking into the property when he came up to me and punched me. The other individual was somebody who had witnessed that first assault and then later was threatened, and so was the complainant in a public order offence. I turned up to court yesterday, got told by the complainant on the common assault matter that the other person wouldn't be turning up to court. This meant that I got in contact with the CPS because as an agent of the CPS, you have to take your instructions from them. I explained the situation and I was told straight away to offer no evidence on the public order offence. That straight away meant half of my case was done before I'd even got into the courtroom. We then moved on to the common assault case, to which all of a sudden the case just became one person's word against what the other person said had happened. It became very clear during the course of the trial that simply we were not going to be able to prove the case to the required standard, and he got found not guilty of that offence. Now, it turned out that the defendant, in any event, was in court, was already remanded in custody due to a completely separate burglary matter in which he had burgled his parents' address. And so we moved straight on from dealing with the common assault, in which he was found not guilty, the public order offence, where we hadn't even started and we'd offered no evidence on it, to suddenly moving straight into sentencing on a completely different, unrelated matter altogether. We then had other cases later on in the day where they were just driving cases. I had a Section 172 offence where it was a gentleman who isn't from the United Kingdom, where he'd been sent the Section 172 notice. And the requirement under the Section 172 notice is that if you are the policyholder of the vehicle and you are the person who the notice is sent to, you have to complete that notice to say who the driver is. Now, the form came back, and it had the driver's details on it, and it then had the driver's signature on it. And we knew that because we had access to the driving licence for the driver, and the signature was exactly the same. So we were there, effectively having a trial on this person who 4 times had sent this same form back in, because each time he got sent out a new form, and each time they tried to make it clear to him, you must complete this form. It cannot be the driver who completes this form. You yourself must do it. Bold, underlined, put in different spacing. They were desperately trying to do what they could to make it clear to him that it had to be him who completed this form and not the driver. The case starts. It was a Section 9 trial, so I was just presenting all of the evidence through witness statements, handed up all of the exhibits, went through all of the dates, went through the law with the bench as well, highlighted to them that it was incredibly clear in the circumstances that the defendant, even though he had tried to complete the Section 172 notice and had provided the information, he himself hadn't done it, and therefore it was technically a breach. We move on to the evidence that was given by the defendant in that case. He was there with an interpreter. He was unrepresented, and so you had the legal advisor at the court asking him questions in chief to try and draw out his explanation. And understandably, he was saying, well, yes, I got this form, it was completed, and we sent it back in. And then I got another form, so I completed it and sent it back in. And this process had been repeated 4 times. I brought up on the screen because we have click share in magistrates' courts, if you're not aware, where you can project things from your laptop up onto the computer screens. So I pulled up a copy of one of the forms that he had completed and said, right, this person's name, who is this? And he said, that's the driver. And I said, right, the signature at the bottom, whose signature is that? And he said, that's the driver's signature. And I said, okay, and who put that signature into the box? I did. It turned out that he worked for a company. The driver of the vehicle left the company, and he had a copy of the driving licence of the driver. Because English was not his first language, he thought the signature box was the signature for the driver. It became very apparent. In actual fact, he had completed himself all 4 of those forms that had been sent back, but he had effectively forged or put the driver's signature onto the form each time. It was a very peculiar situation because the magistrate actually turned on me in that scenario and said, I don't get it, Mr. Cain. Why is it that the police, in this case, haven't specifically said to him, it needs to be your signature in that box? And I had to explain to the magistrate, well, think about it from our perspective. All we are receiving each time is the driver's details and the driver's signature. We're not going to automatically assume that someone will misunderstand the form, someone who may not speak English as their first language, and may think that what they were supposed to do is put the driver's signature into the box, even though it wasn't the driver themselves that was putting the signature into the box. In that case, the bench naturally felt very sorry for the defendant, and they actually found him not guilty of that offence because they thought he had effectively done what he could to try and inform them of who the driver was in that case. Thinking about it, I actually think the bench were wrong in that scenario. What they may well have done instead is found him guilty because technically it was still a breach because the form hadn't been completed correctly. He hadn't sought any advice from anyone. He hadn't asked anyone to read the forms for him before he completed the forms, but they then could have moved outside of the guidelines and given him no penalty for the commission of the offence. It goes to show that there are many times within criminal law in which you will start a day on a particular track and you will walk out of court at the end of it and think, how on earth did we get there? What happened? That is not what I expected to happen at all. There will be other days in which you will have cases that will crack and fall apart before they get to the end. There'll be other cases you will turn up expecting them to be very easy and they'll be very hard and complicated instead. This is a profession for people who like variety and who like challenges. If you like doing the same thing over and over again, this isn't likely to be for you. Any other questions?
Oh, no, sorry.
Oh, yeah.
On that note, I'm afraid we're
Excellent.
on that note, we'd like to join in.
Thank you.